Hello, my name is Frank Prey. I'm an employee rights attorney. My office is here in Newport Beach, and I limit my practice to representing employees. In fact, I've spent the last 16 years of my practice devoted exclusively just to that. I'm a graduate of University of San Diego School of Law. I was a member of Law Review there. I've been practicing since 1977. In essence, I chose this field of employment law somewhat by accident, and I think somewhat by design. I have always had an attitude of wanting to represent the little guy. I've always felt it most gratifying to get a positive result in the face of difficult odds. Of course, when you take on a big company, it requires a lot of persistence and some resources. I do my best to bring everything I've got to obtaining my client's desired outcome. Now, my client doesn't always know just how much they should demand, and that is because they don't understand the law or the dynamics. So part of my job is to bring clarity and guidance to that process by explaining the law in terms my clients can understand and discussing strategy with my client on the assumption that indeed they are intelligent persons who can make decisions with counsel. When I look at a case, I look at the case from the viewpoint of, is there liability? How great are the damages? Can we collect the money? And are there any sensitive issues that may influence the settlement? Liability is simply a matter of looking at the elements of the case, which are set by law, and then looking at the evidence that we can present to satisfy those elements. Each and every element has to be satisfied. Of course, there are no perfect cases, and the evidence will be stronger or weaker on each element. And that is why, frankly, many cases settle, because the parties can't predict if the burden of proof will be met on every element. Damages simply refers to your emotional and your financial loss, or your economic loss. In employment law cases, that's the loss of money, your earnings, your bonuses, your commissions, your benefits. It can also mean some incidental and anticipated or foreseeable additional losses, such as the loss of your home, the loss of your credit rating, perhaps the loss of other assets that you had and would have been able to keep but for unemployment. And of course, the emotional damages are very real too. There's nothing more stressful to a family and to our relationships with our loved ones than dealing with financial loss, particularly the loss to self-esteem associated with losing a job. So in brief, your testimony, even without the corroboration of a psychologist, is often sufficient to persuade the trier of fact, that is, the juror or the judge or the arbitrator, that your damages for emotional injury are real and substantial. In certain of my cases, in the area of discrimination law, you're entitled also to recover your attorney's fees. This always makes my clients happy to hear. Of course, we have to first win the case, but when we win the case, it is the judge who decides what amount of fees will be awarded. It is not the jury that makes that decision. The jury decides whether you have won your case, but then your fees are presented as a cost bill to the court, and it decides what amount of fees are appropriate. And sometimes, frankly, the amount of fees can be substantially greater than the amount of the actual damages that are recovered, because judges realize these are difficult cases and that attorneys who take on these kinds of risk should be rewarded proportionately. Well, finally, we also think about the sensitivity of the issues. Sexual harassment is always something that is a sensitive issue, particularly if the harassment was by a high-ranking officer of the company. Or perhaps the matter concerns an allegation of some fraud in the company, and the company does not want that to be publicly proven or exposed. These are factors that would lead a company to possibly discuss settlement early in the process. But ultimately, the issue is, has an injustice been done, and what recourse is available to correct that? It is often my dream to find perfect justice, but it will not happen in my life on this planet or yours. But we can approximate that with inaccurate and incomplete measures such as money. And that is the best we can do. And there are costs associated with justice. There's the administrative cost of the courts and the taxpayers. There is also, of course, the cost of hiring competent legal talent to represent you. However, as a plaintiff's attorney, it is my particular economic approach to work on a contingency fee. Now, contingency fees are of different kinds, and I will negotiate those terms. But contingency fees often also include a provision that you will pay the cost of the litigation. And those costs can include the cost of taking depositions, the cost of filing fees, the cost of expert witnesses, and the cost of the juror fees during the trial. In conclusion, this has been my effort to just tell you a bit about myself, about how I see cases, and how you and I might work together to evaluate a case. On my website, you will find a questionnaire which you are free to complete and submit for a preliminary evaluation. If it looks like there's something in that information that would be a case, I will invite you to meet with me, and you will get a very clear idea of the strengths and weaknesses of your particular matter. And I always make a recommendation, and when my clients ask me, well, what can I expect in terms of outcome, I give them my best estimate. Of course, I have to qualify that as simply an estimate. But I try to answer all your questions as directly and clearly as possible. So thank you for this opportunity to introduce myself, and I hope that you and I may have the opportunity also to meet face to face. Thank you.